If you knew that your screw up, there was a guy wasting away in an El Salvadorian prison because you made a mistake, I don't know how somebody sleeps at night knowing that.
I would feel bad.
Yeah, I would feel bad.
I would feel bad. And this is the kind of degeneracy that having a sociopathic, authoritarian, fascist leader creates in a society.
Hello, everyone, and welcome to George Conway Explains It All. To Sarah, I'm Sarah Longwell, publisher of The Bulwark, and because I'm not a lawyer, I've asked my good friend George Conway from the Society for the Rule of Law to explain all the illegal news to me. What's up, George?
Well, there's more illegal news every week.
Yeah, I mean, the thing I'm most eager to talk to you about is Trump signing these executive orders yesterday to have Miles Taylor and Chris Krebs investigated. But I'm going to save that for the end because there's a lot of other legal news that has happened since we last spoke. And right. I want to dig into that first. And the first is, so the Alien Enemies Act. Okay, so we finally have a few preliminary decisions from the Supreme Court. And I want to talk about first the Trump v. JGG. So in a 5-4 decision this week with all the female justices dissenting, so that includes Amy Coney Barrett, the court held that while individuals detained and facing removal under the Alien Enemy Act are entitled to due process, they have to bring a habeas petition rather than proceed under the Administrative Procedure Act. I don't think we need to get into the weeds on this, but broadly speaking, this is a narrow procedural holding, and the court said folks contesting their removal from the country under the Alien Enemies Act need to do so via the correct procedural vehicle. So if you had to read some tea leaves here, what did we learn about the Supreme Court's posture toward the administration, right? Because the reason I want to talk about this first is we're just starting to get some feedback from the Supreme Court about how they're going to handle these things. And Trump's painting it like they're big wins, but they're really on these narrow procedural grounds. So explain this to us, please.
Well, I mean, this case is a bit of a kaleidoscope in terms of the ruling and whether or not it's good or bad. And I think the best way to characterize it for the moment is a mixed bag. Some people see it a harbinger one way or the other. I think it's just too early to say. And it is a highly technical, weedy, get into the weeds issue of whether or not you have to bring suit under the Administrative Procedure Act, which is the way you challenge almost any agency decision, including those of ICE, and then habeas corpus, which is what basically the traditional writ that's existed for centuries, by which you challenge an unlawful detention. And there are lots of arguments both ways as to whether or not these cases are properly sound in habeas. It's not clear to me that the court was right, not clear to me that the court was wrong. I mean, one argument that it was wrong is that these people were actually not necessarily challenging their detentions because they were already detained. What they were challenging was their deportation, and normally the way you challenge a deportation is under the Administrative Procedure Act. But that being said, the thing that the court said that was most unhelpful to the administration, which got not as much play as it probably should have, was that every single member of the court agreed that these individuals, before being whisked out of the country, were entitled to the due process of law under the Fifth Amendment. And that's very important. In fact, the majority opinion said that these individuals, before they are whisked out of the country by whatever means, are entitled to notice that they're about to be whisked out of the country so they could bring a proper case under the procedures of the habeas laws. So that is actually a rebuke to the Trump administration, and in particular to Stephen Miller, the non-lawyer. I'm not going to use a non-lawyer goon who basically tweeted the other day that these people are entitled to no process at all, which is just not true. And actually, it was conceded by the government that they are entitled to process. And it was, that basically, as the case came to the Supreme Court, notwithstanding that the government gave these people absolutely no due process, they, in fact, notwithstanding the Alien Enemies Act requires the president to issue a public proclamation, they did this in the middle of the night before they issued the proclamation. And they whisked these people out without a hearing. That being said, the government actually conceded, because it had to in the Supreme Court, that the Fifth Amendment applies and that these people are entitled to due process, and all members of the court agree on that. Now, the question is how you bring the case. If you bring it as a habeas case, it means you probably have to bring it in a different district, maybe, in some cases, because you have to bring a habeas case in the district, the federal district in which the unlawful detention is occurring. And that may be, for example, in Louisiana or Texas, but there's also a rule that if the person is being unlawfully detained outside the United States, there's some case law that says that the proper venue is the District of Columbia. So that's one problem that potential habeas petitioners and challengers now face, is they have to bring it in different districts, and some of these districts may not be as favorable as others. Although I think there was a case in Texas just yesterday where a court granted some temporary relief. And then the ACLU also brought a case in the Southern District of New York, because there are some individuals being held there who are potentially subject to deportation. And they, interestingly, brought that habeas petition as a class action. It's not clear, how that's going to work, because everybody's circumstances are different, and class actions require a commonality of issues. And there is a commonality of issue here, in that, are there enemies at all? Are these people enemies at all? Because we're not at war with anybody. Did anybody invade anybody? Are these people invading us? Well, I don't think there's an invasion within any meaning of the word. So, but, these cases are going to proceed on a different timeline. And I think at the end of the day, most of these issues are going to get resolved one way or the other.
Well, this is, I guess, let me try to put it back to in layman's terms, which is there are substantive questions about the law that are at the heart of these cases.
Correct.
But we're not even talking about those things yet. Right?
No.
Like, none of the cases are at the point where the things that they're considering, or the rulings that are coming down, actually address that point. Like, can you use the Alien Enemy Act?
Are the prerequisites met? The prerequisite being that that there's a war or an invasion. I mean, is the fact that there are gang members in the United States who came here at various points in time, is that an invasion with the meaning of the statute? I can't imagine so. It's not an invasion. It may be other things, but it's not an invasion, and it's not a war. Certainly not a declared war.
And so these, and I think this is where you might find people to be confused, right? So you talk about Goon Stephen Miller, right? He's out there banging huge win for the administration or whatever, but there is no ruling on the substance of these. Like, we're not even, it's all procedural, and it's all about these technicalities of how the cases were brought. And so the Supreme Court in no way is deciding on behalf of the administration. Now, although I do wonder, they're basically the TROs, right? There's temporary restraining orders that have been put in place on all these federal judges. It does seem like the Supreme Court is saying, well, we're going to let these proceed while we get to the substance of the cases, right? Yeah. So does that belie any, just underlying support for the administration?
I don't think it necessarily does. I do think the Supreme Court is intervening more than it probably should, because what happens when it intervenes at these stages is that they make these pronouncements that may not be accurate, because the record isn't fully developed yet. And one of the things that the Supreme Court historically in our lifetimes has done is it has tried to defer deciding things until all the issues have been properly sifted out at the district court level and the Court of Appeals level. I mean, the issues have a way of crystallizing where you figure out, okay, these 5 issues that mattered and lawyers spent weeks on in the district court aren't really the ones that matter. There's one issue that comes up that matters, that everybody's disagreeing on, and that's the one that the Supreme Court should decide. And that really is the modern function of the Supreme Court. And every time they get involved in one of these, what Steve Bladdock, my friend, calls shadow docket cases, they run the risk of creating more confusion. So, that's a legitimate concern. Although, it does give the administration a chance to characterize things, but, there's a technical term for what this administration does when events happen, and that's lie. I mean, they lie about whether this was a good decision, even though it directly contradicted. Yes, I understand that term. It's a common term. They lie about the fact that this wasn't helpful to the administration, and that these people are entitled to the very due process that Steve Miller says that they are not entitled to, and he tried to deny them. And it's just like people saying, "Oh, what a genius move the president did yesterday by calling off the tariffs that he implemented and insisted he would not call off hours before. It was a genius move." They just say, they say anything. So,
just as a side note on the tariffs thing, because we're not really going to get into the tariff stuff today.
No, we're not going to get into that. But it's another example of lying.
It is an example of lying, but also, so obviously I think Trump is, the worst president of our lifetime, a bad human being. I do just get a chuckle sometimes, though, when he forces all of his minions to go out and die on the idea that no, we are not bending on tariffs. They are good. We are going to reshore American manufacturing, and Trump is a genius. And then Trump
until 3 o'clock the next afternoon.
Trump pulls the rug out from under them, and then they all have to run and be like, "Oh no, now Trump's a genius because he paused the tariffs and look at the market."
He paused the tariff, right? Yes.
These dummies. Anyway,
and then they're going to say he's a genius tomorrow when he puts them back on again.
Sure.
Yeah.
Okay, so you bring up this point though, the way that the administration runs out and sort of says that it's getting handed a win in these procedural cases, right? And the way it's positioning it publicly. And so there was this other interesting, it's another one of these narrow procedural decisions that came down last week. It's in a case called the Department of Education versus Louisiana. And so this was also a 5-4 decision, except this time it was Chief Justice Roberts allying himself with Justices Kagan, Jackson, and Sotomayor in the dissent. But the majority voted to stay a Massachusetts district court ruling that had ordered the federal government to continue to pay out approximately $65 million in teacher training grants that the Trump administration had claimed the authority to cut off. So this is one of those Doge things, they cut this off. Court said, no, you got to keep paying this out. So it was being paid out. Supreme Court now says, nope, it can be cut off. But there was a footnote in Justice Jackson's dissent that was very interesting because normally, and you can correct me if I'm wrong, when justices write these things, they don't take in the political context. They try to be absolutely outside of any political context and just keep things strictly legal. But in her footnote, she wrote, other than paving the way for the plaintiff state's immediate suffering, it appears that the primary effect of today's emergency stay is to hand the government an early win, a notch in its belt at the start of a legal battle in which the long-term prospects for its eventual success seem doubtful. And I don't blame the government for trying. If you're likely to lose on the merits, why not use the court's procedures to fight on new and creative fronts? The government has now gotten this court to nullify clearly warranted interim injunctive relief, deflecting attention away from the government's own highly questionable behavior, all without any showing of urgency or need. Well, that's interesting. She's basically saying our court's just trying to give them not a substantive win, but a procedural one for show that also ignores, it was the court is acting as though there's no urgency about the law breaking that is occurring. Like, did you find this to be interesting or illustrative in some way?
I found it to be very, very unusual. And it's just not, it is not, I mean, they do it sometimes, but it's not often that the courts are explicitly talking about basically the PR and political effects of their rulings. And in the context of these expedited rulings, a lot is being read into them that doesn't necessarily tell us where the ultimate result of the case is going to land. And I think that is the point that Justice Jackson was making there. But it's really, really surprising to see her put it in those terms. And it's kind of disappointing that there's a member of the court who feels that the other members of the court are either doing that intentionally or acting in a manner that creates these misimpressions. I mean, I think one of the things that needs to happen with this court at some point is that they have to kind of stand back, and unless a district court ruling is absolutely off the wall, let it ride. And that really has been how the court has handled emergency applications most of the time during most of my career and most of our lifetimes, basically. It's really hard to get expedited relief this early in cases. I mean, the expedited relief that you get is when something just completely irreparable is going to happen in a case that presents issues of potential importance that the Supreme Court ultimately will have to resolve. And it's just not clear that these cases meet that traditional standard. I mean, it's not a circumstance. The death penalty cases, those are different because there's absolute irreparable harm. You can't fix it if somebody's executed. But for some of these cases, it's just not clear that the government is suffering irreparable harm here. So they have to pay out a grant that they've already paid out. It's just money. It's just a drop in the bucket. And the case is going to be expedited, and there'll be more litigation to clarify the issues. And really on the merits, as Justice Jackson points out, seems like they have a case. And it may be that they would not have issued these injunctions, these early TROs or injunctions, and ordinarily TROs aren't appealable. But the court shouldn't be taking its time with a lot of this stuff at this point. It should wait for these issues to come up fully briefed and fully matured, so they can really focus on the most important issues of the case, which they're not doing right now.
Yeah. Okay, we need to squeeze in a quick advertisement here, pay some bills. Is coffee not giving you the same boost anymore? If so, I know it is not for me, man. I am so tired. You and I, this is like the second thing we've done. Like, we just were last night doing a late night little road show. And so, I am constantly looking for a way to, I don't know, man, pep myself up. So if coffee's not working for you the way it used to, it's time to try Mud Water. It is a cozy mix of cacao, chai, turmeric, and adaptogenic mushrooms to help you feel focused and balanced, not wired. Because I know I'm always like kind of jittery here, and George is always amped up. All of the ingredients in Mud Water's products are 100% USDA certified organic, non-GMO, gluten-free, vegan, and kosher. And there's zero sugar and no sweeteners mixed in. The best part about Mud Water is it sustains your energy without the spikes and crash of traditional coffee. Their matcha starter kit is essential. It is the perfect way to step into clean energy with matcha's calming focus boost, which you need if you are doing multiple podcasts every single day. Head to mudwater.com. That's MUDWTR.com and grab your starter kit today. Right now, our listeners get an exclusive deal up to 43% off your entire order, plus free shipping and a free rechargeable frother when you use code AskGeorge. We use our little frother in the office constantly. For whatever reason, that little frother just is great. I don't know if you like frothing things, George, but
I do like frothing things.
Yeah, it's a good little milk frother. We drink it at the office here, feed it to the kids. They're just like, they're funny. The guys here, they're like, it's like Factor meals and mud water. And like, this is how I keep them, charging, because I got to do all the podcasts, but like, they're the ones that do all the prep and stuff. So it's not just me that needs the boost. I got to keep my team hyped up all the time. So they're all drinking their mud water. Okay. Ready to make the switch to cleaner energy? Get up to 43% off your entire order, plus free shipping and a free rechargeable frother when you use code AskGeorge. That's right, up to 43% off with code AskGeorge at MUDWTR.com. After you purchase, they'll ask you how you found them. Please support our show. Don't forget to put your code in, because we need you to support our show, and let them know we sent you. Keep your energy natural and refreshing all year long with mud water, because life's too short for anything less than clean, delicious energy. All right.
Yeah.
See, I've had my mud water.
Mud water.
See how good that was?
Yeah. Awesome.
All right. Before we get to Miles and Chris, I want to ask you about just another thing that is one of these incredibly troubling things going on in the administration.
Right.
And by that, I mean the DOJ. So in the case of Kilmar Armando Abrego Garcia, a senior DOJ attorney admitted in court Abrego Garcia had been accidentally sent to a high-security prison in El Salvador due to an administrative error. DOJ then put that government lawyer on leave, for failing to zealously advocate for the United States, meaning Pam Bondi and the Department of Justice are disciplining their own lawyers for telling the truth in court, which they have a professional and ethical obligation to do. So if that truth is contrary to the administration's position, they still have to tell the truth. Like, that's their obligation. Is this have you ever seen anything like this?
No. And I mean, it's really a remarkable case for a number of reasons. The first is that the government concedes, right? This lawyer had to go into court, and he's a long-standing, experienced government lawyer, to go into court and basically defend something that the government conceded was wrong, because they had no basis to remove this guy. And they don't contend otherwise. Their position really is, without evidence, that they can't get him back, because he's now in this El Salvador detention facility, this guy who basically was never convicted of a crime. There's no evidence that he's a member of a gang. All right. The evidence that had been previously cited by the government years ago was that he was wearing a Chicago Bulls cap or something like that. He's well-known group of terrorists from the 90s. He lived in Beltsville, Maryland, peacefully for years. He has an American citizen wife, and he has an American citizen special needs kids. And they basically carted him off and sent him away without making any determination, a legitimate determination that he was a member of, which was what the basis was originally, was a member of MS-13. And now the government says, sorry, we can't get him back. So I don't know. You're going into court. It's hard to be, it's zealous just to be able to stand up there and take the abuse that a judge is going to give you, taking a ridiculous position that the government is making you take, which is that we have no help. We have no way of helping, even though we are paying the government of El Salvador millions of dollars to hold people for us. Somehow we have the power to make them take people, even if they're not legally in custody or legally deportable, yet somehow we can't even ask the government of El Salvador to say, sorry, there's this one we shouldn't have sent you, so could you send him back? We'll send a plane. And I don't know exactly what it was that this fellow said. I'd like to go see the transcript that they objected to. But I think probably that he was just embarrassed to be there. And I can't blame him for being embarrassed to be there. He made some concessions before the court that they didn't like. But sometimes you have to do that to maintain your credibility to the court. And as you point out, to live up to your obligations as an officer of the court and a member of the bar. So it's really, really appalling. It sends a terrible message to people in the Justice Department. I think it's going to encourage more good, decent lawyers to leave the Justice Department because they see themselves as being forced to engage in unethical or questionable activities and making representations before judges or making statements before judges that they can't really justify.
Can I ask you a question that's like not really a fair question that I don't know why you would know the answer to, but why can't we just get this guy back? Like, it's so strange to me. We're the United States government. You would think they would just be like, they've already said, like, we did an oopsie and it's a bad oopsie. Why wouldn't they go get this guy and bring him back? What's the problem?
Because then there are a couple of reasons, I think. One is it'd be politically embarrassing to the administration in a way that making a concession in a brief or making a concession at oral argument in front of a district court would not be because you'd see the guy would be getting off the plane, then he'd go back home to Beltsville, and then the press would descend on him, and they'd interview him, and they'd interview his wife, and they'd interview his kids. How did it feel? What was the prison like? First of all, it would be greatly politically embarrassing to this administration. That's point one. And point two is the whole object here is to get people out of the country and just not take responsibility for it. Not take responsibility for making mistakes. They don't care if they make mistakes. So they want to set a precedent. I mean, this is, again, this guy is from El Salvador. He's not one of the Venezuelans. It's a completely different case. But they want to set a precedent where they can do as little as possible to determine whether or not somebody should be deported. Okay, that's the front end. And on the back end, say, if they make a mistake, sorry, we're done. Can't do anything about it. Oops. And, that's just it's just a recipe. It's a recipe for lawlessness. It's designed to be lawless, but it's also designed to create maximum fear, and it's designed to create maximum publicity for what the government is doing without creating publicity for the mistakes it's making. Does that make sense?
Well, it makes sense. And I just want to offer my expert analysis, which that sounds downright evil. You have sent somebody with no record. You admit it was a mistake and you won't get them back.
Yeah, no,
it's disgusting.
Here's what you have. You have a president who's a sociopath.
Yeah.
I get on broken record, but he's a sociopath. He's surrounded by a lot of other sociopaths or people who are willing to accede to his sociopathy. They don't care about rules. They don't care about laws. They don't care about other human beings. What they care about is exercising power over other people. And, they don't care.
This is like one of those things, though. I just have to say, like a halfway decent person, if you knew that your screw up, there was a guy wasting away in an El Salvadorian prison because you made a mistake. Like, I don't know how somebody sleeps at night.
I would feel bad.
Yeah, I would feel bad.
I would feel bad. And so this is the kind of degeneracy that having a sociopathic, authoritarian, fascist leader creates in a society. You've got these ICE agents wearing masks. Why are they wearing masks? They're not undercover CIA agents. They're wearing masks because they're ashamed of what they know what they're doing is wrong.
Yeah.
Okay. And then everybody.
And because they know there could be accountability down the road because
there could be accountability down the road because it's wrong. And there's also this diffusion of responsibility that we've seen in other eras and other places. It's like, well, I'm just following orders.
Yeah.
I was told to do this. wasn't my decision. It's above my pay grade.
Right.
And, that's how horrific things happen in a society and to a world.
Yeah. Speaking of you doing things to try to scare people, speaking of retribution and doing awful things, yesterday, on Wednesday, Trump issued a bunch of executive orders and presidential memoranda. And one was an executive order against the law firm Sussman Godfrey, the firm that represents the Dominion voting systems, including its $787 million settlement for lies about the 2020 election. And they also filed an amicus brief on behalf of former government officials in the Perkins Coie litigation. So what do you think? Is Sussman Godfrey going to fight this like Perkins and Wilmer and Jenner? Or
I think they will. I don't know this firm the way I probably did 20 or 30 years ago. I remember interviewing at Steve Sussman's house in 1986 in Houston. He had this big house in River Oaks, the River Oaks neighborhood in Houston. And he was a really smart guy and a really, really hell of a trial lawyer. And he didn't take any shit from anybody. And this firm it's sort of a hard-nosed firm, an honest, a good, skilled, really top-notch. They only have the best lawyers. They hire the best lawyers, and they pride themselves on taking tough positions and bringing tough cases and winning them. I think I don't think it's in their DNA to cave. And I don't think they have a corporate practice at all. There's a pure litigation firm. So they don't have this problem that I've been describing, that these New York firms or these firms are trying to be like New York firms have, where they have these very, very lucrative transactional practices that require at some point government approval for the transactions to occur, and then for them to get paid huge fees that are percentages of the deal. So I don't think they will settle. I think they will fight. I think they are probably the wrong target for Trump here. I don't know why they've chosen Sussman Godfrey, but I'm glad that they're choosing someone I think probably won't settle.
Yeah, well, it means I
could be wrong. I could be wrong. I mean,
Sure.
maybe the character of the firm has changed over the years. Maybe there are some compelling circumstances, but I think a pure litigation firm that does a lot of plaintiffs' work is not going to be the type of firm that's going to cave to this administration.
Yeah, good. All right. So in addition to that EO yesterday, that executive order, Trump also issued two separate presidential memoranda against individuals who were former government employees. So one, and we know both of them, and we should just say that up front. One was Chris Krebs, the former head of CISA, which is the Cybersecurity and Infrastructure Agency. So they oversaw like the implementation of the election in many ways, or the protection against like foreign actors, things like that. And the other one was Miles Taylor, who had worked for DHS, the Department of Homeland Security, and in 2018 published an anonymous op-ed criticizing Trump. And then he authored a book about the chaos of Trump's first term, also anonymously. And then he came out right before the 2020 election and said, like, this is who I am. And I got a couple things about this. So I was on TV. I was out doing Nicole like while this broke. And so I got asked about it. And I actually at the time didn't understand the difference between the presidential memoranda and the executive order. And so my first instinct was like, what is he doing issuing? I mean, it's already insane enough he's issuing executive orders against law firms, right? Executive orders are these are policy things. And instead he's just using them. I mean, he said he would retributively, like to go after people. But now instead of just even going after institutions, he's going after individual people who he's pissed at because of how they acted in 2020. And we can take them separately, but like, it seems insane for Trump to be going after individuals like this.
It is absolutely insane, and it is pathetic. It is insane. And, I mean, whether you call it a memorandum or an executive order.
Do you know the difference? Like, what is the difference?
I mean, I'm sure there's a technical difference, but at the end of the day, an executive order is a memorandum that goes out to agencies that gives them directions. And
just to be clear, he was telling the DOJ to go investigate them. Like, that's the memoranda. Right. It's like, go investigate these guys.
That is the most remarkable aspect of it. I mean, apart from the punitive and retributive aspect of it, the fact that he is telling the DOJ to investigate without any predication. Normally, when to start an investigation under the DOJ manuals, under basic prosecutorial decency, prosecutorial professionalism, you need a predicate. You need some reason to believe that somebody committed a crime. These memoranda don't describe anything like that. They're jokes. I mean, the case against the criticism of Krebs is that in the course of doing his job at CISA, he made a determination that the 2020 election was not the subject of widespread fraud, which every sane person, every non-delusional person agrees with. Never been any evidence.
The Chris Krebs allegation, I mean, obviously it's all crazy, but like the Chris Krebs allegation is really, really scary and insane. Hey, everyone. Thanks for watching the show. If you want to catch the rest of this episode, then go become a Bulwark Plus subscriber. The link to become a subscriber is right below here in the episode description. Click on that, become a Bulwark Plus subscriber, catch the rest of the show, and support all the great work we do here at the Bulwark. Thanks, guys.
Well, George Conway, he's a man with a plan. Got to sit down with Sarah Longwell, take a stand, explain all the legal problems they're piling high. With Donald Trump, oh my, oh my, oh my. He said, Sarah, let me break it down for you. There's obstruction of justice, corruption too, the legal tangles and troubles, they're growing fast. It's a storm that's gonna last and last. Oh, Conway, tell Longwell all about it. Those legal problems can't live without it. From the emoluments to the Russian ties. Oh, Sarah, listen close.